Hello and welcome to the Punished for Protecting Live broadcast with your host, Francesca Amato, national expert in the Americans with Disabilities Act, domestic violence and child abuse advocate, best-selling author, and founder of Punished for Protecting Incorporated. We welcome all of our viewers watching on Facebook via Punished for Protecting News and the CPS News Network. If you're watching on YouTube at Punish No More and Free to Protect, be sure to like, subscribe, and hit that bell icon. You can also find Punish for Protecting News on Rumble. Now, without further ado, here is your host, Francesca Amato.
Good evening, everyone, and welcome to my live broadcast, Punished for Protecting News. No matter what venue you're watching it on, we welcome you tonight. We have a great show for you this evening, and one that we had to push off a little bit. I did have an emergency last week when this was supposed to air, but I am so happy and so excited tonight to have this amazing guest that is an ADA expert as well. And his name is Jay Shore. And without further ado, I'm going to go ahead and bring him on out with my assistant, Hannah Morris, who's also working in the capacity that I am in this nation regards to the Americans with Disability Act, as well as domestic violence and child abuse and all the various things that happen to families and children due to a lot of negligence that's occurring in our family courts. So without further ado, I'm going to go ahead and bring out to start, and we'll be bringing out Hannah shortly. But without further ado, oh my goodness, Jay, it's so great to have you on the show this evening. Welcome to the broadcast.
Thank you for having me. I appreciate the opportunity to talk, and I appreciate the work that you do as well. And this is what it's all about, is getting the ADA to be the tool to make things more accessible for individuals with disabilities. And I would posit, especially for individuals with invisible disabilities. So that's,
Yeah. And that's what I really want to touch a lot on tonight when we have this conversation, is a lot of stuff that you and I both see in the courtrooms, because we get to observe what's happening within these courts throughout this country. And also my assistant, Hannah, which let me go ahead and bring her out onto the screen as well. Hannah, hello.
Hi.
hello.
Hi.
I'm so sorry. I was in the waiting, or I was waiting, and then I got cut off. So sorry about that. It's nice to meet you.
Good to meet you too.
So we all get to observe what's happening nationwide within these courtrooms, and I know that you do that as well, correct, Jay? You've seen courtrooms throughout the country as well, or do you do certain?
Oh yeah. I was in a couple today.
Yeah, us too. So we see different things in different courts, though, and really, when it comes to the Americans with Disability Act, shouldn't we be seeing all the same? Shouldn't it be the same across the board?
Well, different courts have different procedures, but yeah, they're in my opinion, and this is not mandated under the ADA, but in my opinion, courts should be proactive and implement a screening process for people to at least be asked if they have a disability that would affect them in any way participating in court. They don't do that, and the minute somebody brings it up, if they're not with somebody who's an advocate, there's usually a blowback on it. And I mean, I'm an advocate, and I feel like I'm decent at what I do, and there's still blowback on it. So
yeah, well, even today, I mean, I see Francesca probably stepped away to deal with something, but I feel like it's been more profound lately that that it's come up that so all the state statutes have embedded in their factors, which are usually about 9 factors that they have to consider if we're talking about child custody and visitation, the general mental health and well-being of a parent. But as we 3 know, we are under the ADA, we don't adjudicate disabilities, we adjudicate patterns of behavior. But in the courts, they take this and stretch it so far and oppress people with it And then we see parents scrambling to try to prove there's nothing wrong with them and all these things, when there's something wrong with everybody at some point, and probably in family court, everyone, right? If you're in a protracted custody fight, you probably need an ADA advocate, right? It's all of us at some point. So we can talk about extremities, but like Francesca always says, when we talk about personality disorders and kind of pathological things, those are things that create dangers, but they also show patterns of behavior that can flag that as something to attach to. But what we see is we're just going to label things and then walk back things we think will fit that narrative. We don't see mom or dad has these patterns and we're going to focus on that. What we see is just let's call someone mentally ill and then take their kids, even though they're not even showing us. And actually the other parent is often not even accusing them of patterns of behavior that are harmful to the child. So the harm is in that approach. And even today, just it's flags all the time, but in the personal sphere, it's flagged, like in my state today, and it's actually very distressing. And I don't know how, I feels like something that shouldn't be that difficult, but it actually in its process is extremely difficult for some reason to explain to attorneys. Like I don't want to take over interviewing you, but I really want to know. I know, right? Francesca's laughing. I'm actually very curious what that experience is like for you. When you see a good parent who has a traumatic injury from the experience, and then people are trying to label that parent and not looking at how they are a parent, but just that they may have a label. And so we're going to take your kid. I really want to know what other people are experiencing.
So are you wanting me to speak to that?
Yeah, I would love to.
Okay. So, a lot of times even attorneys will chip in and bring the heat on an opposing parent and insinuate that they need to have an evaluation.
Mm-hmm.
The thing is, what I would like to see happen and what I'm trying to implement, and hopefully a lot of people can help with this, is that if you go ahead and invoke the ADA, and when I say invoke the ADA, a lot of times people say, well, how do I do that? Well, what you do is say, I'm claiming rights under the Americans with Disabilities Act. Mm-hmm. And if you are regarded as disabled, if the minute they say anything about mental health or psych eval, that's the time to say, I'm invoking the Americans with Disabilities Act, and I demand to have no coercion, intimidation, threats, or interference. And I also demand to have equal access. And I also demand to be treated fairly here. The thing is, once you do that, though, you're taking away their immunity, the court's immunity, and the opposing side, the lawyer, a lawyer's office, and a lawyer operates as an office. So their office has to be accessible to you, even if you're not a client. And so they cannot discriminate against you either. And so once they do, it's time to invoke the ADA on them and tell them that they're doing the unlawful acts in 42 U.S. Code 12203B, which are coercion, intimidation, threats, and interference. And this is just, it's counterintuitive because people are so afraid. First of all, the word disability is stigmatized. Secondly, the mental health piece, it's a fear piece because people say, especially the men or women with PTSD, they don't want to, neither sex or gender wants to be seen as having a disability. They don't want to be seen as having a PTSD. They don't want to.
Well, because once you get a sniff, sorry to interrupt you, once you get a sniff, if you happen to be in family court before you know any tidbit of what we know, you see how that's weaponized against you, and that they're ready to do it, they're willing to do it, and they're preemptively even ready to do it. So then when you think there might be something wrong with you, then you're scared. But we obviously are trying to flip that script, because anyone who's in, again, one of these protracted family court cases is going to have a traumatic experience, and you're going to need that support.
They're in trauma. Yeah. And I wanted to have this live broadcast for the audience. There's a couple different reasons. And, Jay is an expert. I actually saw Jay. I guess we were part of a case a long time ago together, and we didn't get to really work together. And then I kind of found him on TikTok, where he's got a viral audience, and I was just very impressed. And I know that, and I believe you know this too, Jay, that I haven't seen any other ADA advocates in the country have the knowledge base that we have. and Hannah now has too, and how we incorporate it with all the other laws, such as human rights, constitutional rights, Hannah with all the educational rights and so on, how this is all incorporated together, domestic violence, how it's all incorporated together. But when we invoke the ADA, or we invoke any of those, I call it like the Holy Trinity, like human rights, constitutional rights, and the ADA, you really monkey wrench them in the court. Wouldn't you agree with that, Jay? Like, you really can stop them from abusing these families even further. What do you have to say about that? Oh, you're mute.
Yeah, you're muted.
All right. The ADA is the BFH. And it's the big fucking hammer. And I don't know if we're allowed to say that on here, but I have alopecia, so I'm gonna.
That's okay.
But and the thing is, when I've talked to attorneys about this, it came up recently in a conversation that attorneys really don't know what's going on with the ADA. And the reason is, first of all, it's an unfunded mandate by Congress. So there's no money for businesses or courts or state and local governments to be compliant. And then secondly, they've cut out punitive damages in Titles 2 and 3. So the state and local government piece that we work with a lot in courts and schools and jails and so forth, there's no punitive damages there unless you tie in, like, and this is not legal advice, but 1983 claims and other claims that are available to mirror and attach for those. So lawyers are not incentivized to thank you. Lawyers are not incentivized to take ADA cases, and they're not really aware of what the ADA is. It's a gloss over in law school. I've heard this many times. And I mean, I work with lawyers, and I'm sure you do too. And they admit we're not taught how the ADA works. And so
they say they've had a cursory special education. Like I do editing for a Christian legal society, and they'll say, like, and this is not a criticism that they're amazing, but they'll say, yeah, we have a few classes, and then there's continuing ed. But generally, we're finding that either attorneys are admitting that they have some education and they want it, or they feel threatened by it and they don't know how to navigate a situation with a retained client who has brought us into the situation. And a lot of times they don't want to, because it makes them feel like they're rattling the cage of the court. It's taking them away from the norm, and they don't want to do that, which I think is a big mistake. I really do.
Some of them are literally running, and I know the reason is because they're blacklisted and they're threatened by the entire bar association, which the judges are a part of. We're running into, in certain states, we're running into judges literally acting like kitty cats, literally just completely respectful, asking me if they follow the ADA properly, asking, applying it properly, going by, I do a letter. So I do an actual letter with the federal codifications and the specifics of what my client needs. We go through, Hannah is ready to take her head and slam it against the wall sometimes, because they'll say, you can't file this in because it's ex parte, knowledge of the truth, not versed in the ADA at all. We've got that. So we run into two sides of it. We run into judges that are highly respectful. And I was shocked about that, because I am the biggest person out there to expose these judges. But I ran into that in many states. They're really, really careful. They've been super, super kind to the clients. The clients can't even believe that they're being treated like a human being all over again, when they were treated like complete dog poop prior. So, and it's supposed to be in compliance. Your court order is supposed to be in compliance with the ADA. Okay. It's supposed to be reflective of the ADA, which that's why I say it monkey wrenches them. And like you said, ADA, BFH, big. Yeah. I love that. And that should.
What was on my court transcript? Oh, the ADA, that's separate from this. No, it's actually not. Like, that was a judge said that. That was on my court transcript. Maybe I shouldn't even be saying this, but that's separate from this state court. No, it's actually not.
I'm glad you said that. That's where I'd like to hear I'd like Jay to kind of expound on that.
Yeah.
So I'm trying to say that it's separate from their court. What do you want to say about that?
Back to the lawyer piece real quick, so I could finish that thought real quick. When I go into work with a lawyer, I always tell the lawyer, look, you're going to have to paint me as the bad guy, period. And a lot of times I'll get blowback. No, we don't need to do that. Well, yeah, you are. You're going to have to, because you can't stand up to the judge. You're not allowed to. I can. And so you're going to have to make it look like I'm actually putting you in harm's way if you don't let me do that. So, and actually, I intend to put them in harm's way if they don't let me do that, because they're going to be discriminating against my client. But to the court piece, if the court says, no, that's a separate issue, then I would say, for clarification, Judge, are you saying that you're not a covered entity under Title II of the Americans with Disabilities Act? Then I would just wait. I would wait for their answer.
If they let you talk, that's the thing. Okay, so we're going to have her here and she can't talk. And it's like, no, that's not how this works. So it becomes sometimes, and it's usually not the case. Let's say this is usually not the case. The problem is that it's when it is the case, you have colliding forces. So you've almost got a judge, or rather, well, you do have the judge, but you have counsel of your client who's supposed to be, you're on the same team generally, saying, oh, no, I'm not going to make waves with the judge. That's going to make me look bad. Not necessarily I'm not going to be able to advocate for my client. They'll put their client in harm's way to save themselves. That's what I've seen. Okay. They are number one. I'm not going to ruin my reputation. I'm not rattling anyone's cage, right? Even though they're supposed to zealously protect their client. And we all know that. I'm saying all the things that everybody here knows. But it gets a little dicey when it does come up that way. And then you're not allowed to say anything. What? They don't understand the depth of what we're allowed to say and how deeply we can stand in for a person that is perfectly capable, and stand in for them and say, as obviously we've gotten to know them and what their voice is and what they want. So that's where I think the major tension is.
So let me paint a word picture here.
Okay.
So think of a blackboard or a whiteboard, whatever, on a wall, and you've got a line down the center of it. On the right side of that line is at law. That's what's going on in court. Those are the substantive matters of the court case. Okay. That's whether or not somebody shot somebody's dog, or, whether or not somebody met for visitation or followed their parenting plan, or what, all that stuff's over there on the right side. Okay. Mm-hmm. That line is the separator line. And on the left side of that line is administrative ADA access. And so anytime during the right side of that board, during the substantive matters of that case, when their ADA access is removed, all of a sudden that your client, my client, is plucked up out of that side and thrown back over here into this side, and this is not even taken care of. And I feel like, and I have challenged this numerous times and have not yet had the opportunity to stare this down in a court case, and I'm willing to and want to, but I am willing to, at that point in time, to say, hold on a minute, you just removed their ADA access. They do not have ADA access right now at this moment in time, and that's administrative, and you need to deal with it right now, and you need to deal with it in a private way.
I've seen you do that. I've actually watched you do, and I didn't know your name or anything, but I've watched you talk about this before.
Yeah, well, I mean, it's
the substance of the whole thing. I mean, and the case law is very clear that when judges fail in this administrative capacity, they're not subject to immunity.
Right. And I try to remind them of that as often as possible. Today, I had a judge that had been, and occasionally, you've talked about judges being kitty cats. I've not ran into that, but I have ran into judges. I think I think the feminine energy brings a good piece to it.
I was going to say, I think the masculine energy brings a forceful, so there's a good blend there.
Well, I mean,
yeah, I've had both female and male judges be extremely respectful, which when I tell you, Kay and Hannah, this was several months ago it began, and it's been going.
I know.
It blew my mind, because anybody that knows me for the past 15 years, I've been exposing them by name and face and media and every way possible.
I know.
Thinking they're all demon spawn, literally.
Well, we know, I can think of, and I won't name the person, obviously, but there was a woman that we helped, and she said, and this is a very contentious, very long-standing case, that her judge said, look, I want to give the opposing party custody, but because I know this is going to look like retaliation, I'm not going to, because she was so public about her case.
I remember that.
So there are multiple sides to it. I would love to know your thoughts on, actually so many things. I mean, because there's this, I talk about this in my support group a lot, because women, and I'm saying women because that's mostly what we're dealing with. I'm not discounting men. Obviously, we can say that disclaimer ad nauseum, but that have been in these cases for so long and everybody's calling them crazy. And then the ADA thing comes up and they think, I don't know, that's going to make it look worse. What do you say to people that are stuck in that mindset because of how kind of gaslit, well, not even gaslit, just indoctrinated by the courts, knowing what the court's attitude is toward without even behaviors being flagged? I'm going to say that over and over again. Under the ADA, you cannot adjudicate disabilities. I'm saying that over and over again because it bears repeating, but you can in family court adjudicate patterns of harmful behavior, like a narcissist, like someone that's some kind of a psychopath or something, but you have to point to the behaviors. You don't just say, so-and-so has this, I'm concerned. Okay. So, but when a lot of these mothers, they are already being targeted because maybe now they have anxiety, maybe they have depression, they have postpartum, whatever it is, things that are transient, maybe things that are caused by the courts, things that don't preclude good parenthood. Most of them don't. I have not yet, in the year I've been with Francesca, had a client with her that actually had something that made us say, maybe there is a reason she shouldn't have time with the child. How do you talk to your litigants that are terrified to admit they need you?
So regarded as, if there are three prongs to the definition of disability. There's actual disability, there's record of a disability, and there's regarded as disabled. And oftentimes the people who are afraid of using the ADA are already regarded as disabled. They're already being accused of either some type of behavior or something that causes them to be a quote unquote threat. Now, let me tell you this. If you deem someone a direct threat under the ADA, there's like 7 criteria that they have to meet to go through this. Individualized assessment, best objective medical evidence, the nature and severity of the risk, the likelihood that the harm will occur, whether it will be mitigated by accommodations. And I've missed a couple, but there are 7 criteria and they never go through this list. But once they deem someone a direct threat, either by words or inference or actions, then they're already at a disadvantage unless they use the rights that are available to them. So they can go in and try to muscle this out. And I mean, I'm a guy, and it took me years to go get a diagnosis of PTSD. Then I got a diagnosis of social communication disorder. And both of these helped me greatly because I know what I'm dealing with. And now I also know what I can ask for in court, which is not what they want to hear. But so I'm telling my clients, look, either you're going to go in and you're going to be regarded as, and you're not going to claim your rights, or you're going to go in and you're going to be regarded as, and you can set up a barrier for them to use that against you any further. So it's your choice. I mean, I'm not here to tell. I don't sell my services. I hate selling myself. I realize that I am doing what I have been put on the planet to do. It took me a long time to figure that out. I'm cousin Eddie on Christmas Vacation. You know, I was holding out for a management position for 8 years. You know what I'm saying? And I found my management position. This is it. I'm an ADA advocate.
Yep.
Can I ask you what? So, and I'm not saying this out of somewhat ignorance, but because I don't know what you would say, but also because I know the people that are listening. When you say set up a barrier, what can you say more about that? Like you personally.
Once you invoke the ADA, the rules change.
Right.
And y'all know this.
Yeah.
And so once you invoke we talked about the wrench. Well, that's the wrench. So when you invoke the ADA and you put it in writing, I have 4 rules. Know who you are. And and the part of that is assessing how the other side's already treating you. Are you already being regarded as disabled? Know who has the burden of proof. They have the burden of proof on proving you're a threat. Okay. But they do not they cannot place the burden of proof on you to prove that you're disabled under Title II of the ADA. That happens in federal court, not in state court. Okay, so when you have to have a prima facie case, and all of this that I'm saying today is absent intent or authority is legal advice. I want to make that clear. But shit, I lost my train of thought. So when tell me the question you asked again, Hannah. I apologize.
Repeat that because I want to ask you about just because it makes too much background noise. Oh, she just popped out. She's going to have to get back in. She got knocked out. I wanted to ask you, and I don't want you to lose your train of thought. So when she comes back, we ask that, but she got kicked. She'll be right back. You just mentioned you were diagnosed with PTSD, and then you said, what was the other disorder?
Social communication disorder.
Yeah, social communication disorder. This is a very interesting topic that we could probably do another show on, because like I know obviously you and I are speaking the same language, so I know how beneficial this is for all of our clients, everybody that goes through the family court or any court for that matter, criminal court, or any type of situation that they get themselves in that causes trauma, okay, in their life. And of course, but talking about that, can you talk a little bit about what that means? Because as advocates, excuse me, pardon me, as advocates, we have, let me just take a drink. As advocates, we get like vicarious trauma, so to speak. So like I know this stuff in my sleep, but sometimes I need to go back and look at something in writing, and then I can start going like a train wreck against the court with it. Kind of touch on that a little bit if you could, and then we'll have Hannah re-ask you that question.
Okay. I think I just posted this in my Telegram group, but let me see here. DSM-5 has a social communication disorder in it. And what it is, it's a context disorder. And so to tell you how I realized that I had this, when I was a kid, I had parents that would beat the hell out of me and tell me they loved me. And that my legs would be bleeding, and they're sitting there telling me how much they love me. And it just didn't compute with me. And so then I ran into a school and a church that said the same thing. You're going to get cancer if you don't do this. And basically it's what they wanted me to do, not exactly what God wanted me to do. But and then I ran into a judicial system that said, we're here to provide justice for you. And then, oh, by the way, bend over. And so all of these things have combined in my life to make me really wary of words, because what people say is not actually what they mean. They're trying to couch their phrases and their presentation in a way that best suits them to get what they want. And usually that's you performing some act. So if you're in a conversation with someone, and I mean, even in this conversation, we're trying to promote the ADA. So we both have a generalized goal that is alike. But in an adversarial setting, that's not true. And so I have social communication disorder, and it's a context disorder. So the context of words are a real problem for me. I actually hate pronouns. So when somebody's talking about them and they did this and that, when they're in writing. So when somebody's writing, I'm like, who did that? Who did that? Because they'll mention a name, and then further on down, there'll be this pronoun that's ambiguous, and it could point to several people, and I don't know who it is. So it's a problem for me. And I'm not saying this in any kind of way that talks about the current use of pronouns. I'm talking about when you in legalese, in legal speak, in legal presentation, and even in documents. So we've all signed end user license agreements. We install a piece of software, and we have to click I agree. Okay, I agree. Okay, and in the end user license agreement, it's talking about you. That's a different pronoun. It's a second position. So it's not I, it's you. So I mean, all of these things, they drive me mad. And so when I get into court, and I think a lot of people have this because courts use language that is really slippery and can't be nailed down. And I think it's just something that's not mainstream and not yet diagnosed in people. So I've done videos on my TikTok about social communication disorder and went through the DSM-5 on it. So you can go there and look, but it's a thing where a court will say one thing or an officer will say one thing, and it's just not the truth, and especially for me, and like any kind of police interaction is going to be a problem for me, because, not only do they have training on how to use speech, they have the legal right under Frazier versus Cupp to lie to you. And so I just have a card that I carry around with me to say, look, I have communication disorder. I want to talk to your designated responsible employee. And I cite the ADA, put the laws in there. And I've got one instance of this working so far with me doing this. I've also got one instance of me doing it and the cops screwing up very badly, putting me in the back of a police car. I freaked out. I'm 6'6", 265. And I freaked out, and I could have sued them and won.
Yeah, for sure.
But I couldn't revisit the trauma. I mean, but I documented it. So it's easier to do advocacy for somebody else than it is for yourself. But back to social communication disorder, most people don't understand when somebody says something, when a lawyer says something, or a judge says something, or a court order says something, it's usually something ambiguous and it's not at all clear. And if you ask questions, a lot of times they'll say, well, we're going to hold you in contempt if you don't follow the order. So I mean, we'll get to that point.
Several things that happen in the middle of what we're doing with these very, very convoluted cases. By the time we get them, they're all twisted up like a pretzel, and we've got to start untwisting and doing a lot of house cleaning, and then just basically taking it down to the nitty gritty, getting the courts to see that this is why we're really here, not all this other, I call like the pig pen dust garbage, cleaning that all out, invoking the rights, ADA rights, and so on and so forth, and everything that you're talking about right now. And also, like you said, when you have to revisit the trauma that has caused damage to you, you have the rights to win this stuff, but you just don't want to revisit it. Most people don't want to revisit it. That's what we're here for. We're here to kind of take them through gently, push them through, block them, protect them, and bring them through to the end, so that when we're fighting for each individual family, we're fighting this whole thing on a whole. We're fighting the Department of Justice. We're getting the Department of Justice to do the right thing, since they are the main venue. We're fighting the courts. We're fighting the attorneys. We're fighting all these people just to make sure that rights that already belong to you are adhered to. Number two, we're doing this because we're trying to, which was something you and I talked about pre-show, Jay, and I think I did send you some of the information on that, is risk prevention. Okay, we're not supposed to be damaging human beings on the left and right of us. We're not supposed to be doing that. They take an oath to do no harm, and then the ADA clearly protects people from anything that would cause them further damage and risk, which is what's happening. So what we have in front of us as ADA advocates and advocates on a whole is a very serious job. I mean, there's a lot to what we do. It's not just about the individual in front of us. When we're fighting for that individual, we're fighting for an entire nation full of victimization and violations. But going back to, and I know we could probably have a show that lasts for 20 hours because there's so much information that we each have and that we have corporately together, the three of us here. But Hannah, you did say something. You had something that you were saying to Jay before you got kicked out. And if you don't mind touching on that, do you remember what that was?
Gosh, I think the only reason I'm not totally sure what I was saying is because he also just said so many things that I want to ask him questions about. I think what I was asking him before I got bumped out was about how do we quell, I think, the anxiety in litigants who are already getting a sniff of how disabilities, big or small, like you might even have ADHD or some anxiety or PTSD from a domestic violence situation, and something that's artifact from what's happening. Okay. And the litigant has already been in the situation in the family courts for enough time to get a whiff that anything wrong with you is going to be used against you. So I think what I was asking was, how do you give them the confidence that, or at least the comfort that invoking the ADA is going to be an asset and not make it worse? Because like we both were saying, I think both of you have said this. I know Francesca and I actually had something earlier that we talked about this. Literally the attorney said this. Now we're just confirming what they were already trying to use against you. How do you speak to that client and let them know this is an asset to their case? This is a protection.
Not just to the client, Jay. How do you speak to their attorney when you're working?
Right. The attorneys are usually the harder people to get through to because they're not willing sometimes to operate outside. And you said you're fine with them, you being the bad guy, the fall guy. I'm all for that approach. in the oppositional attorney, I haven't seen that be a comfort. I've only seen them, look, here's the state statute. That's it. We work within these confines. I don't want to look at this. I don't want to rattle anyone's cage. I don't want to talk about this or that thing. And they can't understand how broad reaching actually the role of an ADA advocate can be. It is very broad. We can literally stand in the place of a client and speak for them and things like that. And you know that because you'll speak in court and you're jumping in. I've seen you do it on, I don't even have TikTok, but I've seen some of your videos where you're speaking directly to judges and the litigant is there. They don't realize that that's perfectly legal in this capacity. So I know I've said too many things now. Good luck.
A lot of times, if I get blowback from an attorney, I'll send them the link to the video that I did. And I had a talk when I was going through training. Dr. Huffer pointed me to William Gorin.
Mm-hmm.
And William Gorin writes the book for the American Bar Association on understanding the ADA. It's called Understanding the ADA. He's probably working on his 5th edition of that book. The one that's out now is the 4th edition. But and there have been a lot of changes since that edition. But I called Mr. Gorin and I talked to him. This was when I was in Portland. And excuse me, I yawned. I recorded the call because I knew this was going to be an important conversation. And it was a one-party consent state, so I had the ability to do that. But nonetheless, I asked him about ADA, how to hold judges accountable. And his words were, and I paraphrase, a lot of attorneys are afraid to take this stuff on because courts will fight back hard. And I'm paraphrasing, but not much. And they will threaten disbarment and other proceedings. And so I'll play that video. I'll send a link to that video to an attorney and say, look, this is why you cannot do what I can do. You can't. And when I had my channel, when I was in Portland, I had a channel called Luck Lawyers Institute. And it's a spoonerism for lawyers. And I had 13,000 subscribers. And I just gave a lot of information about how I dealt with courts. And this was before I was, certified as an ADA advocate. It was when it started. I had been fighting the system for a long time because of my social communication disorder and PTSD. I just didn't know how to fit in. Mm-hmm. And so I asked him this, and I got that conversation going. I recorded it. I sent it to attorneys, and I said, look, you're just going to have to paint me as the bad guy. How do I paint it to a client? Do you know anything else, client, that will take the immunity away from a judge? Do you? Well, if they use your disability against you, which they're going to do, they're going to try to do this. They're going to try to get a psych eval. They're going to try to get the information to use against you. And anytime they ask for a psych eval, they're asking for that information, in my opinion, to use it against you. Anything you say can and will be used against you.
They're telling you, I always say they are preemptively telling you they're going to use it against you. That's the only reason to go for that.
So I'm going to hold your thoughts right now because we're about to go to a commercial break. For those of you that are watching, we cannot bring you into, I see some comments. We cannot bring you into this. This is a StreamYard broadcast. You can watch this on YouTube, Rumble, Facebook News, which is Facebook Punish for Protecting News. It's on live right now as we speak. And you can watch it after the show is live on Rumble, YouTube, Punish No More, and Free to Protect channel. And my Facebook page, which is under Francesca Amato on my main profile. So you can watch it off of any of those channels. And it is live right now. It is now, Wednesday evening. And it is 8:43 p.m. Eastern Standard Time. And the show is live. We're going to go to a commercial break. And we're going to have much more with Jay Shore and Hannah Morris.
We'll be right back after a message from Punish for Protecting Incorporated. Each new generation of protective mothers is shocked when they first go to family court and find it doesn't favor single mothers and is willing to jeopardize children. Francesca's harrowing experience with the broken family court system, from which she finally received justice after 8 months of struggle, is proof that there is light at the end of the tunnel. Francesca has one of these unspeakably cruel cases and has responded by shining a large spotlight on widespread failures so other mothers won't be shocked. Punished for Protecting the Injustice System of Family Court by Francesca Amato Banfield, advocate, mother, whistleblower, founder, and TV talk show host of Punished for Protecting. If you are struggling with injustices wrought by our courts, this book will help guide you through the process. Available on Amazon.com. Search Punished for Protecting and get your copy today. Help abolish family court by purchasing Punished for Protecting merchandise. Here are our top sellers. See the link in the YouTube video description to find out how to get your Punished for Protecting t-shirt. Get your high-quality Punished for Protecting t-shirt while supplies last and let everyone know that you stand for justice. Are you being re-victimized by the family court system? Do you need help with your case? Go online and book a talk with Francesca. Go to punished4protecting.com/book-a-talk. Fill in your name, email address, and message to Francesca. Someone will get back to you within 24 hours. Francesca and her staff of volunteers continue to work tirelessly every single day for parents and children who are in need of their help. There have been multiple success stories, including Francesca's, which gives hope to others in similar situations. Punished for Protecting Incorporated has incurred out-of-pocket expenses with zero funding to help families get their children back or to save their children from being taken. We also have provided funds to help with retainers, food, lodging, and travel. We really need your help so we can continue to provide our many services. Any amount is greatly appreciated. If you'd like to donate or sponsor a family in need of help, go to Cash App, Free the Children. And now back to our broadcast.
We're back with Jay Shore, 88, and Hannah Morris from my team. Where's Mike? There we go. So let's go back to some more questions to you, Jay, about some of the things that you've been experiencing, both negatively and positively, in the courts that you've been observing and so on.
I regularly see judges interfering with ADA rights. Just today, I told a judge that she had to give my client privacy concerning the ADA and the accommodations, and she went and talked to the head person at the state and came back and said they talked with legal counsel, and legal counsel said they don't have to give your client privacy concerning accommodations. And I'm going to have to write a letter and tell her she's wrong. 28 CFR 35.160B2 says they must provide privacy. So, judges can be wrong and often are wrong in my line of work. So that's one of the things that I regularly run into. They want to bring this shit into court, and it's just not where it belongs. It belongs in an administrative ex parte hearing, and many states' judicial canons allow an ex parte hearing as long as the other side does not receive a strategic a tactical or procedural advantage. And this is not meant to do that. This is meant to give them access to court. It's not about the substantive issues.
You know, with me, it kind of, and I agree with you, it kind of really blows my mind that some of these attorneys understand what we talk about. If you do a forensic ADA report and you're showing them the federal codifications and you're, you know, kind of spitting them out of your mouth from your brain, not even looking at anything, knowing they know that you know what you're talking about. They know that we know what we're doing and what we're talking about, yet they still will say things to you like, I don't think that's discrimination, or, I mean, we hear it all. That's ex parte. You can't, you know, invoke their rights without, you know, everybody knowing about their PHI. And, you know, but when I hear that, it's like, it's either one of two things. It's that it's just so dark and so corrupt, and it's been happening for so long that they truly believe themselves, or that they're terrified of being blacklisted. And I tend to believe it's a little bit of both, because the federal laws, the federal codifications under the ADA are so clear. They're impenetrable, right? They are what they are. I mean, no matter where you go on this earth, no matter where you put your feet on this earth, any place that you place your feet, if you are a qualified federally protected class member under the ADA, you are that no matter where you go. It makes no difference in a court, and the ADA says so. Court buildings, it says it. It's like, you can't get away with it. Welfare, it says, you know, anything, it doesn't really matter. So how are these intelligent people making these statements that they make to people like you and I? Do they really think we're going to believe them? Or like, you know what I'm saying?
There's an old joke. Do you know what you call the dumbest person in law school?
What?
Your Honor.
That's a good one.
A judge? No, I'm just kidding.
Yeah, well, I mean, you know, if they were smart, they'd be out doing what the guys raking in millions and millions of dollars are doing. But you know, they're using their skills for a power play, and that feels good to them. And when somebody like me or you comes in and tells them, so I had an interview with Andrew Esquire of Legal Mindset, and I told him, I said, I have a hostile work environment. I go in and I tell judges, you have to give my client ADA rights. You can't intimidate, coerce, threaten, or interfere with them, and you have no immunity. So I mean, anybody who's accustomed to doing things the way they want to do them, and have somebody like me or you come in and tell them that, there's going to be a little bit of blowback, and in some cases, it's a lot of blowback. So.
About that word.
I have a few questions when you guys are ready for them.
Hold that thought. Don't forget
Okay.
that, please, because
I
we have
won't.
limited.
I'm writing them down.
We have limited time, and we want them on this live feed. And Lily decided to join the show tonight.
Oh, hey Lily, my kids love you.
I got one behind her too. So the word immunity. Now I really feel like this whole immunity thing, I call it the get out of jail free card for the judges. You know, this has been something that was imposed upon the people without our vote. That's first of all. Okay. You can't just have somebody up there. They are judge and jury. They are everything. Okay. In these family courts, and they have zero accountability. Do you know, are you aware of this, Jay? This one makes my brain want to just explode. When a judge says he's going to be under advisory because he's not ready to decide on something, so he's going under advisory, do you know that there's nobody that advises him? There are no experts that advise him. He's not going up the food chain to like a higher judge and an ethical team of people to discuss the medical aspects or the ADA aspect or the aspects or whatever the aspects of are that decision he's making. When he's under advisory, he's simply just dealing with himself. Nobody else, just him and himself. Okay? So he can make a decision. That is a recipe for danger. Danger. Okay? So if we don't invoke such things as human rights, constitutional rights, Americans with disability, federally protected rights, we have a big, what we've seen, major injury happening to individuals, okay, which eventually affects an entire nation full of people, which it's been doing. Now, I just want to say, so that's why I'm so annoyed with the word that they have this immunity, and obviously they do lose it with the ADA. They lose it with constitutional rights too. But here's the cool thing. We have more immunity than they do, right, Jay? We have more immunity than they do. And to top it all off, the qualified federally protected class member under the ADA likewise has immunity. Do you want to talk about that?
Well, I would like to hear Hannah's questions, but I really want to say this first, that I have actually gone in and told judges that they have no immunity, and it's fun watching them squirm, but man, they don't like it at all. They do not like that at all. What you just asked me though, Francesca, what was it? I'm sorry.
Oh, I basically said that we as ADA advocates
Have more immunity?
have more immunity than they do, have more immunity than the attorneys, more immunity than the judges, and so do our clients because they're federally protected class members under the ADA.
Under 42 U.S. Code 12203B, anyone who aids and encourages, and you don't have to be certified to do this, anybody can advocate. And so you are a protected class because you're aiding and encouraging another in the exercise and enjoyment of their rights under the ADA. And that's one of the reasons why we're getting further today than we have been. I see the tide turning. I see the tipping point occurring, and I'm encouraged by it. It doesn't make it easier right now, but there is a bit of hope I see occasionally. So that's why I want to keep doing this. Go ahead, Anna.
That's actually the perfect segue because my three questions are really meaty, so we don't have to. They're probably, each of them are a show unto themselves. But I'm glad you said that about the tide turning and hope, because in as much as what we're doing is exposing the things that kind of feel hopeless, like Francesca was saying, people come and they're in a really bad situation. They have their rights terminated. They're on their way to their kids being adopted out. Like, they are at the end of the line, right? So that's obviously a tough spot to be in and to walk back, right? But we always infuse, and not for any kind of just brevity, but for actually the truth that there's always hope. So I'm glad you said that, because hope is the undergirding to the whole message. And this is why I think it's so brilliant. And I really do think it's a God thing that the ADA exists to this broad and umbrella-like degree, because it can't unequalize things. That's the thing. All it does is infuse the equal footing into the courtroom that is supposed to be there. You can't go wrong with it. It can't do something bad. So that's the beauty of it. So one of the questions I was going to ask you is to talk about some of your successes and how you've seen something turn, or maybe you are seeing something currently turning, a tide turning. You said the tide is turning. Because I think that we always try to talk about that, because it gives a lot of the people that follow Francesca the hope that we really do believe in. And I do believe in that. So I want to know what you say about that. And then I'll save my other two questions.
So one of the cases that I was involved in, and I've got some video about this on my TikTok, but Lisa Gorsuch, who's a judge in Michigan, Oakland County, Michigan, she had received national attention prior to me becoming involved with her 3 years earlier for throwing 3 kids in jail for not going to lunch with their father, who they said they saw beat their mom. And so this judge is just a tyrant, a bully, and I don't understand how she's still on the bench. I mean, she's unfit to be a judge. So when I got into her courtroom with my client, it had been 13 years that this client had been being beaten up by, and this is awkward to say, but in our line of work, I do see judges that are slanted towards one sex or another. Sometimes a judge will be pro men, and sometimes a judge will be pro women, and I mean, I see this, and so in this case, I believe Lisa Gorsuch is pro men, and she's anti women, and so my client was a woman. And so I went in and I was asking what, and my client also had an attorney, and I told my client and her attorney, I said, you're going to have to treat me like the bad guy. And I said, as a matter of fact, in this next court hearing, I'm probably going to interrupt you if the ADA is not resolved, if the ADA access is not resolved. And the attorney gave me the okay to do that. She said, you can feel free to interrupt me. And so I did. I went into the court hearing and said, why are you not giving my client ADA rights? Then I made a call to I made a complaint to the Judicial Tenure Commission. The Judicial Tenure Commission called me, and I recorded that call. They said, this is confidential, and, you shouldn't record this. And I'm like, oh, yeah, sure, right. And of course, Michigan's a one-party consent state. And at the end of the call, he said, Michigan's a one-party consent state, so you could have recorded the judge. And I thought, well, I recorded you. So I put this out where he actually said on this, in this call, I told him what the judge did, and he said, nope. You're absolutely 100% right. She was wrong. She was wrong to do that. And I mean, this is on one of my TikToks. And I mean, he comes out and says that the judge is wrong. So I put the video out, and I said what happened to me the first time I challenged a judge in North Carolina. I challenged a judge in my case in North Carolina back in 2005, and I called the judge out for collusion. I said, I hereby accuse this court of collusion with my adversary. And I went in the next day, and this judge, I'll never forget what this judge said, Lindsey Davis. He said, Mr. Shore has accused this court of collusion, and a reasonable person would not expect an impartial adjudicator after that fact. And I hereby recuse myself of this case. Bam! And he slammed the gavel down and got up and walked off the bench. And I thought, that's a powerful phrase. Would not expect an impartial adjudicator after the fact. So I told that guy on this call, I said, a reasonable person wouldn't expect an impartial adjudicator after being discriminated against that strongly. And he's saying, yep, you're absolutely right. She was wrong. So I went and published this on YouTube, Rumble, TikTok, whatever. And I didn't have TikTok at that point in time, but I published it on the internet. And I sent a link to her. She recused herself of the case. And I keep that recusal order. She did herself on my wall. So that's one of my successes. About 2 months ago,
Awesome.
There's a case that I was involved in. I wrote a letter to the judge. I'm sorry, to the guardian ad litem. And I invoked the ADA, and I said, you are not giving this child equal access to the ADA, to your services, programs, and activities, because the parent has made you aware of a disability that is being caused by the other parent, and you're ignoring it, and you're excluding this disability right from your services. And you're discriminating against this child and the parents.
That's right.
By doing it, and you're not with immunity for this.
Mm-hmm.
And so you're liable, and actually it appears that you're conspiring to do this, and you could be criminally. And I was working with an attorney on this, and the attorney called me and said, your letter did this. Got the GAL, and this is a court-appointed officer of the court.
Yeah.
And the GAL got on the stand and was being questioned, and every question pled the Fifth Amendment. The judge said, we have no choice but to remove the GAL and the reports that they've submitted. And I don't even know if we can get another GAL on this case. Wow. And I mean, that's powerful. That's turning shit around.
That was going to be part of my question, actually. And I'm actually this is really a God thing that you said that, because it's almost impossible to get these. And I don't say that with actually
No,
like,
right.
But in action, it's actually almost impossible to get a GAL off a case.
Or a child attorney.
Right. Attorney for the child. What do you call them? There's so many other ways they call them.
Attorney for child.
Guardian ad litem, attorney for the child. There are other ways they call them, but anyway, if people know, I was trying to think of other ways they designate them just for different parts of the country. Sometimes they say other things, but anyway, people know what we mean. And that's really important, because and this actually is the second part, what's actually in between two questions I was going to ask you, because, and we talk about this a lot, these are the bad actors, unfortunately, in the cases. They influence the judge tremendously. They usually lean toward the abusive parent, and I've never seen it another way. I honestly wish I could give you an example of where that's not true, but I don't have one.
Either after 15
I actually don't have one. Okay. And that, I believe, is based on many factors. I mean, that's every topic we're on could be a show unto itself. So obviously we're scratching the surface.
Jay back again and again and again.
Yeah, yeah. And I really appreciate and respect everything you're saying, because every single thing you've been talking about, and I can see your heart and soul is coming from the same place we're coming from. So actually it makes me feel kind of emotional, because I haven't encountered anyone but Francesca in this realm. And it really has blessed my life to a degree that again, that's another show, that it's really blessing me to hear you talk about it. And what I can sense is an honest way of taking a snapshot of what you see. And I don't want to take over everything, because the only reason I ask these questions, I feel like they're informed by what I know. And I know a lot of the people that are listening. So I'm trying to kind of infuse your wisdom, and obviously it's swept by what we know, and it's all in sync, by the way. I haven't heard anything counter to anything that we believe in. So that's the only thing that's informing my questions. And you already answered part of it with that. So I really want people to know there's hope in that regard, that the guardians ad litem, the attorneys, even though the judiciary threads an immunity to these people, they are subject to the same rules that everyone else is. And so there's a way there. I want people, even though it feels impenetrable, it really does. And it does. But there's a way here, especially because God is really navigating the truths of this in the courts, and we have to acknowledge that. But so you kind of split apart, you answered some of that, and I'm super encouraged to hear you say that. And I want people to really grab onto that, what you said about the GAL. The other part is, and I think it is connected to multiple things you've already said, is, so I'll just put it in two parts. You tell me how it works for you, because my brain sometimes can't separate bits. But on the special education front, what are you seeing right? So we are traumatizing kids so much and obviously, I'll let to summarize this, like this is Cliff Notes. What we're doing with ripping kids from this person to that person, and we may even be talking about middle school kids that have lived with a great mother or a great father all these years, suddenly, and everything's good now. We just made the right decision. And so what are you seeing in terms of the special needs we are creating in kids because of trauma, and then how it's impacting them educationally?
Well, I want you to hold that specific question in thought, because
Okay.
here's a message, and both Jay and
I can't even see because I'm blind.
Well,
but
it's Sarah Stanley, which I've
done. Hey, Sarah.
Multiple stories on Sarah, and and I just court witnessed the other day the egregious, on steroid corruption that's happening in the Idaho court with this Cleve Colson dude.
Yeah.
She and I are going to be spending several hours together. I have a lot in store for this particular court coming up. But she said, how do we hold, and this is in line with what you're saying, Hannah, how do we hold these judges accountable? And I know everybody's pretty much asking this. How do we hold them accountable? How do we hold the guardian ad litems accountable? Like she said, it has been one of the most difficult is to delodge a guardian ad litem, so-called child attorney or so-called attorney for child. It's the same handbook. It's the same nonsense. They don't care about your rights. They care about the rights of the abuser. That's all they care about. They'll talk to you till they're blue in the face about, but the abuser has rights, but you violated the abuser's rights. And they will make up stories. They will make up illogical policies and practices and procedures that are false, to defend the abuser. In her specific case, he was even in another state, and yet he got to move the child into Washington state after they caused her and her child insurmountable violations.
It actually does go with what I said, because that he was 3 when suddenly he doesn't see his mother. Can you imagine?
With his mother always. So from the womb on, he was with his mother in this wonderful life, this wonderful, wholesome life. And I'm hoping that you're not frozen, Jay. I hope that you can touch on that question by Hannah, because it really is very similar to what Sarah Stanley is still suffering. She's still suffering.
The way to hold the judges accountable is to take them to federal court. And this portion of law, I read an article, and I think the article was from 2011, but it says that, and Rhonda's right, but the article was with I think it was the American Bar Association. It was an article, and it said that this area of the law is underdeveloped, and it's underdeveloped because lawyers won't take it into federal court. So what does that mean? That means it's on your shoulders and my shoulders. And for me, I can go in as a co-advocate, as a co-plaintiff, because I have had my rights of aiding and encouraging disabled as well and denied access to the ADA. So I can go in as a co-advocate. And there's a course online, and I don't even know what the website is. I think it's howtowinincourt.com. I'm not sure, and I don't know if I'm allowed to do this here, but this has been around for a long time. A guy wrote a program called Jurisdictionary, and it's a lawyer. His name's Patrick Graves. And you have to learn how to form your case and go in and write paper and submit the complaint and serve it and have all of the meetings and so forth. You have to go through all of that. I did it in federal court in Portland, Oregon. I sued the city of Portland, Oregon without an attorney, and the city settled with me. So, it's on your shoulders. If you want some help with this, you can get help, but part of this you're going to have to do yourself. You're going to have to pick up and do some of the heavy lifting. And that means that you're going to have to go into federal court with this. And it's an unfunded mandate. So yes, that costs money. And people are going to have to realize that they're going to have to, this is a social engineering piece for me. And the reason I am so focused on the social engineering piece of it is because when we get the law to recognize, when I say the law, state and local government, when we get state and local government to recognize through a case that's going through the federal court that they have to slow down a minute and give people equal access, that's going to affect the entire system. So whoever steps up to bat is not just carrying their own load, they're carrying the weight of the world on their shoulders. And I'm here to help, but I can only do so much. And so that has to go forward and go into federal court.
Yeah. And on that note too, they can reach you, Jay. They can reach you for help through, I know it's on your, it's on your, what do you call it? Underneath your name, but there it is again. It's ADARightstrust.com, ADARightstrust.com. And also you can go through us through punishforbeingaaparent.com, the book a talk section. I take people through a very intense intake process and consultation just to see if I'll even take their case, so to speak. And I'm sure you are in as much demand as I am, being that there really are. We found a couple of people here and there, and then we found out some really not so good reputational things. And so really, honestly, I just want to bring forth ethical people. And that's why I really enjoy, watching what you're doing and talking to you about this. But, to work alongside of you or work somehow with you, it would be something that I would be really encouraged to do.
I would enjoy us being in court together.
My gosh, that'd be so great.
I think the first time we were in court together, it was kind of a shock, maybe to both of us. I'm not sure, but if we had it planned, it would be a great thing.
Yeah.
I think so too.
There would, as the Bible says, there would be much weeping and gnashing of teeth. So yeah. I also want to say that on TikTok, I do have a decent following there, and I'm not really concerned about the following. I put a lot of free information.
Yeah.
And a lot of information about how the ADA can work for you. So if you want to go to TikTok and look up certified_ADA_advocate, that's me. And there's a bunch of videos there. And I just try to address things as they come up in my mind. And I've got certified_ADA_advocate.
Oh, okay.
Good. You'll see that. Yeah, you'll see that badge. And if you pull that badge up one more minute.
Sure thing. I think that is the best way to show people. Just remember there's an underscore.
So I designed this, and the invisible disabilities piece with a head with a question mark in it is, that's what I really want to bring about with social engineering, is because when we look at other people, there's so many people that are affected by disability that we really need to be more compassionate as a society, and especially the government that's supposed to give us our equal rights.
That's right. Whatever. Well, wait. They're not supposed to give us those rights. We were born with those rights. We were born they are into us.
We're supposed to acknowledge them. Acknowledge them.
Acknowledge that they're doing to people, and that's why I'm very very big on the whole risk factor, the whole do no harm, and the ADA supports that. The ADA enforces that. Let's also talk about that too, though, because, you know, and that's what I call it, Jay. I call them psychological injury. I do not call it mental health because of the connotation that's behind it and the bad buzzword that it's kind of used. But, you know, and I try to, way I explain to people, I like to use a lot of, Hannah knows this, I use a lot of pictures, I use a lot of C-spot run language, because I'm like, well, let me ask you a question, you know, attorney so-and-so or judge so-and-so. Would you grant or deny a man to come into this establishment in a wheelchair? Would you say, can you please fill out the link on the Unified Court System website and see if I can allow him to bring in that wheelchair? No, you would never do such a thing. You would never discriminate against that man. You wouldn't touch his ADA rights there. You wouldn't even consider it. It's a no-brainer to everybody. Is there a ramp already built out there? It's been built before you even open the doors of this building, right? So we don't have to ask to invoke that right. It's there. So because you can see it visibly, it's a visible disability, right? Then you're approving of that. But because somebody has an invisible disability, post-traumatic stress disorder, anxiety, depression, whatever it is that they have, now you think they have to ask your permission to have some kind of an aid for their disability. Now, you and I are those wheelchairs. We're those wheelchairs. We are those seeing eye dogs, right? We are the emotional support dog. That's what we are, right? Cute ones, of course, but that's what we are. So if they're going to say yes, we'll allow you to come in. Jay will allow you, you know, Francesca, you can come in, but sit in the back. I'm sorry, I'm not there to watch the paint dry on your walls. I'm not there. Then I'm useless. I can write down all the violations that you're committing, like making me sit in the back. But in reality, that's not aiding my client. I am the wheelchair, and you're not letting them sit in the wheelchair. You're not letting them use that wheelchair. You're not letting them mobilize the way they would normally mobilize. Okay, so that is discrimination. That is a discrimination of the Disability Act. You know, you are now not just taking away their equal footing in the court, you are now immobilizing them to operate as any other human being would operate, which is another ADA violation. So, and when I explain it that way, usually what I do is, if we're having a problem in a courtroom with somebody, I'll either go up to the chief judge, or I'll go to usually the ADA coordinator of the court, because now they're throwing out these words, ADA coordinators, and they're putting them in positions all over the country from all of our fighting and work. And when we talk to them, Hannah, you can say it, right? When we talk to them, I'll say straight up, do you know even an eighth of what I'm talking about? No, I'm sorry.
You guys are just handing me all my questions. It's literally like God is like, here, I'm going to just draw the constellation of this whole conversation. Because every time I have a thought, one of you leads me to be able to ask it. It's incredible.
I mean, but that's
because I have so many questions. I almost wish we were like, after this conversation, we could have a separate conversation, because I want to know what Jay has had as an experience with ADA coordinators. And literally that's on I'm writing note. You probably see me leaning to the right because I have so many things I'm writing down, because I have so many books to my left, and you've named a couple books that now I'll be ordering on Amazon after we talk, but also notes, because neither of us are driven by ego. I don't think all three of us are. We want to know what we're doing, and we care about families and people and the stigma and everything you said. We want litigants to have equal footing in the courtroom and equal access. So have you found, and I still kind of want to hear what you have to say about the educational piece, but I wish I could show you guys my notes, but it wouldn't make sense now. Have you found any ADA coordinators that are well-versed, you know, holistically on the ADA and worked with them to success?
They all say the same thing, that they don't even know it. I know, but go ahead, Jay.
I actually have.
That's good.
Most of the ADA coordinators that I run into are woefully inept, and they don't know what they're doing.
Yeah.
But when I was going through my training, Dr. Huffer said, what I want you to do, she gave us an assignment. She said, what I want you to do is I want you to go to your local court, and I want you to set an appointment to talk to the ADA coordinator and let them know that you're an advocate. You're going through my course and you want to get some information from them. You want to talk to them about what their job entails and how they deal with accommodations and so forth. Well, this was when I was in Portland, and I was in Multnomah County, and I went to the courthouse and I set up an appointment with Jeremy Wolf. And Jeremy Wolf is an attorney. He's also the trial court administrator. At least he was at that time. I don't know what he's doing now.
Okay.
And I set this up with him, and I knew in my mind that I was going to be coming back into court in probably 6 months to fight these tickets that I was getting on a weekly basis almost. But I didn't tell him that. I just came in as an ADA advocate. We sat down, we had an hour conversation, and it was a great conversation. And he actually admitted that he would like to see somebody spank the court. I don't know if he used those exact words, but that was the thought process for not following the ADA, because he said, admittedly, we don't always follow it the right way. So when I had my court hearings, and Dr. Huffer actually helped me write my list of accommodations. And so I put that in, and she also wrote me a declaration for that and federal court. And I'm thankful for that, because she did that before she passed away. And by the way, another book you want to get is Unlocking Justice by Karen.
Oh, I refer to this book I think I actually should get a kickback at this point, because I refer people to that book so often.
All right.
I think it's that Unlocking Justice, and just reach out to Hannah Morris for this.
It's just I've had people say it's not available on Amazon. That's how many people I've gotten to read the book, because it's a good one-stop shop for this topic.
I've got an extra copy, and I also know how to reach George. So if you have a trouble getting it, let me know.
I refer to that book all the time.
Yeah. So anyway, when I went into my court case, I put in my request for accommodations, and the judge actually went through my accommodations list and gave me every one of them. And I credit Jeremy with this, because Jeremy helped me with this. And it was just, at a point later on, I was in a court hearing with Ben Johnson, and I have this on my TikTok, and Judge, the first judge, I can't remember her name. I think it was Shelley, or anyway, she said these accommodations will be for every case you have. And so I came into this hearing with Judge Ben Johnson, and I couldn't get him to answer a jurisdictional question. And I finally called him out. I said, well, that's just bullshit. And he said, if you talk like that again, I'm going to hold you in contempt. And I said, I have ADA rights in place, and you've agreed not to use coercive, threatening language against me, and you're going to do that in court? Do what you must. I told him, I said, do what you must. And he couldn't get off the bench fast enough. Now, he found for the city, and I lost that case. But in federal court, when they settled with me, they wiped all of those tickets out. And in the end, right. I won. So, but it was interesting to see that dynamic, because he didn't know how to deal with that. Because I said, look, I've got ADA accommodations in place. This is not a regular case. You're going to threaten me right here when I've got those accommodations in place? Whew, he was gone.
So it's definitely fair to say, and we've had some good ADA coordinators. I can't say that we've talked to one that was super, super educated, but that we usually, if there is one, and some of these courthouses don't have one, they'll have a person that's like kind of the liaison, and then that person will say, honestly, guys, I don't really know the ADA. They just I'm the default person, because they have to have someone. But usually that person doesn't have a big ego, and they're saying, I don't really know, and they let you kind of lead. But when you have a good one, it can be a hinge factor in this stuff. It can make a big, then you've just displayed that you had a great one, but they can very much be helpful.
If you have a good one that knows the law, then you're speaking the same language, and you don't have to go through all this nonsense. But if you have somebody that's just a nice person and you're educating them, you feel good about it, because you're like, okay, I got them educated. So now every time I'm back in this court, I through all this nonsense. What they're doing in Virginia, let me tell you what they're doing in Virginia. In Virginia, I've had great judges, I'll be honest with you. But as far as ADA goes, I'm not saying that they're doing the right thing by the custody order. But as far as the ADA goes, they've been great. And what's happened is they're making, in certain courts in Virginia, not all of them, okay? It's usually I send my letter, everything is good, and they follow it to a T. In some courts, every time the client goes back into court, they're having us fill out this link. I'm just like, what are you doing? What are you doing? This is such a discrimination to the client, because, again, if it's a person in a wheelchair or they're blind, they don't have to fill out a link every time they go to court. What are they doing? What are they doing? Where are they getting this philosophy from?
I don't know, but back to the ADA coordinators, usually they slap this title on the trial court administrator. And so what I like to do, if I'm in a state where there's and you'll appreciate this, because this is a tactic I use. When I'm in a state that has one party consent and I can record, I'll call them. I have my recorder on, and I'll say, who's the designated responsible employee under 28 CFR 35.107A? And they're of course they start looking at you like a frog in a hailstorm. and so they have to call some people and ask this, that, and the other. They'll finally get you to somebody, and they'll say, well, we really don't have anybody, but I'll help you with that. And my next question is, does this court have more than 50 employees? Because if they do have more than 50 employees, the law says they have to have a designated responsible employee for ADA compliance and grievances.
Oh,
So that's partly why I was asking you that, because some of these courts don't have someone and they're out of compliance because of that.
I just go ahead and catch them in it, write it, and
okay.
going in.
On Title II is what he's doing.
And that way, when I put together my request for accommodations, I go ahead and I put that in writing as well and say that I've got it recorded and this court's already out of compliance, so they're already discriminating. And it puts
I like it.
Puts them behind the 8 ball.
That's really
powerful. Anything you can
do.
Yeah.
Jay, what do you do? What do you do when an attorney says to you, okay, well, now that I've given them like a plethora of federal codifications that they have to follow, I give them the whole lesson that you're not allowed to, your case law and your policies and your practice and procedures cannot violate the ADA. And then they'll say to me, okay, well, can you send me some case law? What do you do when they do that to you?
So I'm in a case currently in Texas, and the lawyer says, no, we believe we're in compliance. I deal with a lot of school stuff too. And schools are notorious for wanting to stick to 504 because 504 doesn't remove their immunity. It lets them bully. There's a whole lot of benefits to just sticking with an old law. And they have to be ADA compliant as well. So I come in and I invoke the ADA. Well, this lawyer's like, no, we're compliant. Show me what you see that says that we're not. So I send him a link from the U.S. Department of Education that says that the ADA Amendments Act of 2008 is the new legal standard. They actually say it's the new legal standard. So the minute I came in and pointed him to this, I said, don't let me tell you. Let them tell you. And the minute I did this, well, he's booted off the case, and here comes another attorney. He didn't even answer me. So, I mean, it's a shell game.
He's just gone. So
it's
well, this is why in special education, the entire education is on, meaning like if you get a degree in special education, the entire degree is about the laws. They don't even teach you about classroom management or any of that stuff because you have to learn that on the fly. The threshold is so high and the tightrope is so thin for special education because there isn't, as of course you have to know your rights and know the law, but there isn't a lot of grace. But these people are counting on the fact, and this is true for the courts too, that you don't know the law, you don't know your rights. And so that's why we talk so much about knowing your rights, knowing the law, and you don't have to be an attorney to say, I know the law. I can read books. And that's actually something we were talking about the other day. Like, as soon as I start making a legal argument, which doesn't have to do with anything special, just knowing the law, knowing special education law, knowing the ADA, I'm talking about it. Hold on, Ms. Morris, we're not making legal arguments. Are you an attorney? Well, I don't have to be an attorney to know the law and talk about it and say, I know my rights.
You don't have to be an attorney to make a legal argument either. I made one a couple days ago.
No, but that's the thing. They think they own this discourse. And it's
the way you verbalized it the other day. You said, what makes these attorneys, what did you say? What makes these attorneys believe that they
I don't know, but you made it sound so much smarter than I said it. So I really liked that. Let's refer to that then.
They have I forget how you said it. I put on Facebook.
They have some sort of moratorium on let's not talk about the law. Did you go to law school? Well, I can't study the law. The ADA is the law. Special education. I have a master's degree in special education. I study constitutional law. I study the ADA. Like, I can't talk about it.
But
I could be wrong about something, and then let's have a conversation. But I'm allowed to talk about what I know my rights are.
Anything that you specialize in and that you're fully focused on, you become an expert in. Okay. And so I have to sit there and I have to listen to all this illegal jargon all day long in these courts, and they're violating rights, and I'm not supposed to speak up. You said that I don't have a license to practice law.
Yeah.
Well, if I can't practice law, then I shouldn't be living, because
I like to ask them, I like to ask them, look, here's 42 U.S. Code 12203B. It says I can aid and encourage. Can you tell me where the demarcation line is specified in this code?
That's right. That's 100% right.
Show me that. Show me where there's a demarcation line.
Mm-hmm. Well, I really enjoyed having you on. I think Hannah got kicked again. I don't really know what happened there. We're going to wrap this particular show, but I guarantee you, especially those that are watching, we're going to have Jay back a lot more. Those that watch this or missed it from the beginning, this will repeat itself as often as you want to watch this particular episode. It is on YouTube, my YouTube channel, Punished No More and Free to Protect. It is also on Rumble, Punished for Protecting News. That's the number 4. It is on Facebook, Punished for Protecting News channel, and it is on my main page, Francesca Amato. If you need help and you want to speak, actually, if you want to speak to Jay, don't forget that you can go. I will have this put on the bottom here. You can go to ADARightstrust.com. That's ADARightstrust.com. If you need my help, you can go to punished4beingaparent.com. That's punished4beingaparent.com. And I really do thank all of you for being on this, being here tonight, watching this episode with our special guest, Jay Shore. He will be back on. We will definitely have him back on. So again, feel free to like, subscribe, and don't forget to hit that bell icon so you don't miss new shows coming up. And boy, we've got a whole bunch of shows that are going to be coming out soon. I am going to be interviewing some people that it's going to blow your mind. And we are definitely making great strides for the future of what we're doing and the work that we have been doing. Hannah's backing. So everyone, thank you guys for being on tonight. It's been a really great program. Obviously, this is something that we could talk about for probably hours and hours and hours and hours and hours.
So nice to meet you, Jay. Really nice to meet you.
Yeah. So thank you again for being here. And I also don't want you guys to forget that we have 2 main sponsors, LyraRugs.com. That's LyraRugs.com. And all you have to do is mention Punished for Protecting for a discount. And another great sponsor is, another great sponsor is it's coming on the ticker. Sorry about that. Is Marietta Mattress at 13B Grove Street, Marietta, Ohio. And it's in the Giant Eagle Shopping Plaza. You can ask for Gara. Her number is listed here, 304-483-7626, or you can go to sapphiresleep.com. This is for very high-end bedding, but if you mention Punish for Protecting, she can deliver anywhere in the country for free. And if you mention Punish for Protecting, she will give you anywhere from 50 to 80% off. So it's really nice. And guess what? This money can go back into helping a family in need. So I really thank these awesome sponsors that can help out our families, because as you know, unfortunately, it does take money to try to help families that are out there. Jay, did you want to say anything before we closed?
I do. I want to say it was great meeting Hannah, and I also want to thank Francesca for having me on, and I hope to see y'all again. And let's connect off of here as well.
Yeah, I'm looking forward to it. Really I think I have a lot I always know I have a lot to learn from you guys. I learn from Francesca all the time. So I'm super excited to have someone else that I feel like I could learn a lot from.
Yeah,
I'm learning from you as well.
I literally just like shrinks from constant information. I can come to you, Jay.
Y'all have a great evening. Thank you so much. I had a blast being on here.
It was awesome. Have you back more often and so on. And obviously we have a lot more to talk about. So everyone, thank you for watching, and thank you for being on the program tonight.
Night.
They claim to be public, but everything is done privately. You can't be both.